The Supreme Court's reputation and credibility is under scrutiny today. This afternoon, a Senate subcommittee will hold a hearing on how the Judicial Conference that handles ethics complaints about Supreme Court Justice Clarence Thomas in 2011 works. This as ProPublica has reported that Thomas did not disclose lavish trips, a deal to buy his mother's house, and tuition at private schools for Thomas's grandnephew, all paid for by a Republican mega-donor, Harlan Crow. Supreme Court Justice Thomas said that the trips were paid for by Crow were personal hospitality, so permitted under the hospitality of friends loophole, and he did not have business in front of the court. Therefore, he believes were not required to be reported. Crow's office said that neither Thomas nor his wife, Ginny, asked him to pay for the tuition of Thomas's grandnephew, and that Crow had also supported many other young Americans in that way. Joining me now is Democratic Senator Sheldon Whitehouse, the chairman of the Budget Committee, who also serves on the Judiciary and Finance Committees. Senator, thank you very much. There's also another issue about Leonard Leo, who's a major conservative figure, who gave Donald Trump the list of potential appointees, nominees to the court, and helped in the vetting of Supreme Court justices, and that he apparently, with information showing that it was to just not disclose, helped to get money to Ginny Thomas, the justice's wife. How can you?
It's a pretty rife mix, isn't it?
Yeah. So I'm just wondering how you can proceed, because you've called on the Chief Justice to investigate. You've called on him to testify. You've tried to get Harlan Crow in front of your committee, and so far without any success. So what are your options here?
So the thing we're doing this afternoon is to look at what happened back in 2011, when very similar questions were raised about Clarence Thomas, including yacht and jet travel gifts from the very same billionaire, and to track how those were treated through the Judicial Conference and its Financial Disclosure Committee, and how that all worked, because that's the prequel to the current allegations that are going to be reviewed through the same process. So I think that's going to be an important look at how the judiciary actually handles this in-house. And while we are ready with legislation, I think it would be in everybody's best interest for the judiciary to manage this problem on its own. I think we'll get some good support for that from the witness that we have this afternoon, a federal judge who was there at the time in 2011. And so by continued pressure, I think the other judges are pretty fed up with this, let's put it that way. And I think the other judges can put continued pressure on the Judicial Conference to take the necessary steps so that this doesn't keep happening.
Now, just to clarify, the Judicial Conference is the group that oversees the ethics for all judges in the federal court system, other than the Supreme Court, which reviews its own ethics.
Actually, it even oversees the Supreme Court in many respects, and it could do a good deal more. They just cleaned up the personal hospitality exemption that Supreme Court justices were using, that no other judge had tried to use that way. And even Justice Thomas said, yes, I'll abide by that new rule. So the court will listen to the procedures to the policies that the Judicial Conference has set up. And they do go through the procedures of the Judicial Conference. So there's more there to work with than you might think.
So Harlan Crow, as I understand it, also purchased Justice Thomas's mother's house, the family home in Georgia. Was that a loophole also? And that doesn't count as hospitality. Was that declared?
No, there's some things that are impossible to excuse under the reporting rules. And one is a transaction that's over $1,000 in real estate that isn't your primary residence. This qualifies. No excuses, should have been disclosed. Another one is jet travel. Even personal hospitality has to be food, lodging, or entertainment. So being flown someplace in a jet is transportation, not food, lodging, or entertainment. And that clearly should have been disclosed. And then we'll go back and look at 2011 and see what was missed in that process, including this directed payment from Leonard Leo, who is the billionaire's chief mischief maker in their court packing operation.
And describe that payment. Is that the payment to Ginny Thomas?
Yes. Yes, this was the instruction to give $25,000 to Mrs. Thomas, but make sure that it doesn't mention that it's going to her.
How do you get this cleaned up? Because the court and some people close to the court are concerned about the reputation of the court.
And they should be. This is really stunningly bad behavior. And nobody knows how stunningly bad this behavior is better than other judges. So I think there's a lot of pressure coming from the other federal courts, particularly the judges who sit on this judicial conference, to put pressure on the Supreme Court to clean it up, to fix up their own rules to clean it up. And they're willing to do that. They just did it with respect to Justice Scalia's trick of saying that a personal invitation produced personal hospitality. They shut that down completely and quickly. So I think there's plenty of room for the judiciary to heal its own injury here. And if not, we have legislation.
And before I let you go, I want to ask you about the debt ceiling talks, because there is optimism expressed from both the Speaker and the White House after last night's talks. They've delegated trusted aides who have the confidence of both sides. Are you concerned, though, that the president has talked about conceding work rules for people on federal assistance programs?
Yes, and I'm going to wait and see what the actual outcome is before I make any decisions about how to react. But I do think it's very, very, very important that the president keep his constitutional option on the table in case negotiations break down. The absolutely worst thing that could happen would be a default. That would be, I think, we always use big words on television, but I think it's fair to say that that would be economically cataclysmic, not only in the United States, but around the world. And that Speaker McCarthy is playing with dynamite whose danger he does not fully appreciate. And the sooner he puts the pin back in the grenade and we can go back to regular order and behave like the Constitution suggests we should, the better off we will all be.
You're talking about the 14th Amendment, and I know Lawrence Tribe has now endorsed that approach, but it would be litigated forever. Could the economy survive?
Not necessarily.
Okay.
Not necessarily. I would get to the Supreme Court very quickly if I were the president of the United States with stakes like the economic cataclysm that would be pending. And I think I could make a convincing argument this is a political question between the president and the Congress, and the court shouldn't get involved. They should call it a political question and walk away and let the branches handle it. And what that does is it defuses the hand grenade forever.
Senator Sheldon Whitehouse, thank you very much. Good luck with your hearing today. Thank you.
Thanks.